check whether the microphone is on.
May it please, my lords, Martha Karua with Muthoni Nyuguto for 3 Amishi. That is Jack. Let me read from the whatever. Dr. Duncan Ojwang, Linda Musumba, and Dr. Ambani. And my lord, we are not here as Amishi. We were Amishi in the Superior Court, in the High Court. But here we have been brought in as respondents by the appellants, and we have responded as respondents. So we are sitting here expecting to get our time, and a lot of allegations have been made against the Amishi and their submissions in the High Court. So we are sitting here expecting to get time to respond, and we have already put in our submissions as respondents because we were dragged here as respondents.
Even when we were Amishi?
We would have come as such, but we were brought as respondents by the appellants.
By the appellants.
Some of whom now question how we are here after bringing us. So we are here ready to argue our case.
Okay, and you would require how long?
We will try, because we are coming after many, we will try our best to compress, not to repeat. But nobody so far, other than accusing the Amishi, nobody so far has put across our points. Yeah.
Okay. Let us see.
Lord, may I?
Sorry?
Ochiel Dudley.
Yes.
I join in that issue with senior counsel. We are sued as respondents, and quite serious allegations have been made against us.
Ochiel, you say you represent one who?
I represent Dr. Jack Mwimali.
Jack Mwimali.
The 14th respondent, a former amicus. My Lord, serious allegations have been made, as a result of which the court even had to admit other amicus because there was a claim that we were not neutral. So we'll request to be heard orally. Thank you, my Lord.
All right. Mr. Kindiki and Professor Kindiki, rather, and team, we had agreed that when we resume, Caroline Cherono, you are there. How many minutes are you going to take?
At most 20.
At most 20. And Professor Kindiki?
My Lord, with your kind permission.
You say 40 minutes. We are just taking the indication, and then we will see what time to allocate.
May it please you with your permission, my Lord?
Just 1 minute. So we will have finished with Third Way Alliance, Meruru Wareru, and Angela Mikali in E200.
E400, my
Yes,
Lord.
yes. And then Mr. Ongoya, can you do with 30 minutes? Yes. What time do you think is reasonable for you, considering that those who have gone ahead of you have covered most of the issues or some of the issues?
You know, let me just address it this way with tremendous respect, Your Honor.
Yes.
I would actually would be laying claim to our entire 2 hours.
Yes.
But we'll try the much we can to ensure that we do not repeat any. Reason being,
yes,
we have a very specific petition at the High Court.
Yes.
It didn't deal with the conceptual issues essentially.
Yes.
It had very specific allegations. The judges gave very specific reasoning to the issues in that petition and gave very specific declarations. There are very specific grounds of appeal that have been raised by the Attorney General against the issues that were raised in petition 402. So I would plead with you, my Lord, to accord us the opportunity, the respective appellants against which specific orders were made to make their case, to also push back that case. If we court, but let us reserve our 2 hours.
Right, we'll come back to you. Thank you.
My lord.
Dr. Eboso. Yes.
I will require at most 1.5 hours to conclude my submissions.
President, with your permission, council, please, and parties, of course you're entitled to your pound of flesh, but we on this side don't have that much to give you each your pound of flesh. You can imagine how much the court has suffered if we have been here, 7 of us, for this entire week. So we plead with you, really. You have put in submissions, very, very elaborate submissions. If there's a way you can, I'm sure, council here, normally in usual cases, you do these things, we give you 5 minutes, 10 minutes, and you're done. This is important, all right, but can you at least try? You can cut that by half. I'm sure it's possible.
My lord, with your kind permission.
My
name is Busiaga.
Busiaga?
Yes, Busiaga. I'm appearing with Kevin Doha Masharia for the Kenya National Union of Nurses. Really, our position has been covered largely by both sides. And if we could be accommodated for 30 minutes, between the 2 of us will have finished.
All right.
We will not go to rehearse what eminent persons have already.
All right. Thank you, Mr. Busiaga. And just a minute, Isaac Oluchier. You need about 1 hour. We're just getting the indications. Miss Kituku, if you can hear us, you appear from Muhuri. Somebody says she's appearing virtually. Okay.
My Lord, with your kind permission, my name is John Mwariri from Kituo cha Sheria. I would wish to echo the request by Honorable Karua that we'll be requesting for 40 minutes. We are led by Dr. Haminwa, both for Kituo cha Sheria and Kenya Human Rights Commission. So our humble request is that you give us 40 minutes for our submissions. That is both for Kituo cha Sheria and Kenya Human Rights Commission.
My lords, my ladies, my name is Devanjiru. I'm just asking probably for clarification. Because when we were granted our opportunity to make submissions before you, we were at least constrained of time, just like, and we were respondents. What happens to the equality of arms? Shall we be granted an opportunity then to do a rejoin of their submissions so that then there can be equality of arms? They are all respondents deserving equal treatment.
My Lord, with your kind permission, my name is Awele. I appear alongside Senior Counsel Otiende Amolo and James Orengo. I'd like to just pitch in from where my learned friend has left. My learned senior, Martha Karua, has intimated that they were dragged to this court as respondents. Speaking on behalf of the second and third appellants, we sued, or rather we filed this appeal and cited the amicus as amici. And even if they were cited as respondents, it was not by choice. It was on compliance with procedural guidelines of this court. The Court of Appeal rules provide that any person who is served with a notice of appeal shall file their notice of address of service as respondents. And so the mere characterization of them as respondents cannot give them the right to then come and substantively take an adversarial position from that which they took at the High Court. We are asking, ordinarily we would not be objecting to amici making presentations. But if the court is going to restrain one amici, or one amicus rather, from making oral submissions before it, I think it is only fair that the court applies the same standard on all amici, because they did not make any substantive pleadings at the High Court or prayers that would warrant them now taking an adversarial position in this appeal. And so I think, even just for the management of time, I think it would be in order if the court were to stamp its authority, their submissions are quite lengthy. We do not agree with the adversarial position they've taken, but we'll deal with them in our submissions. But for purposes of equality of arms, let all Amici be treated equally. Most obliged.
If the court allows me to respond to Mr.
Just senior counsel, before you respond, just hold on. Is there any other party that had filed a petition and I have not called them? Respondent. Is there a respondent who had filed a petition? All right, because I say they were 8 and that was consolidated. Okay. Now, senior counsel, what are you saying? I have basically taken time indications. We haven't allocated time. We are going to make a decision because we must manage time in such a way that we finalize this matter by tomorrow 4:30.
Yeah, I will not take the court's time. I just want to draw the court's attention that in the Memorandum of Appeal, Volume 1 by the AG, Ground of Appeal number 6 is devoted to the amicus, and in fact we are being referred to as purported amicus. So it's really adversarial, and it is in that capacity we have responded.
Okay, we may give you some time to respond, but it will not be the 1.5 hours that you're talking about. We will see how much time to give you, because we agree that there is a specific allegation made about or against your client as Amici. Now, just you all heard what my brother Justice Kiage said. We will have to accommodate one another insofar as this time allotment is concerned. The parties who wanted to file submissions have put in very good submissions, all of you. And so if we were to allocate at most 1 hour or so, we think it will be possible to accommodate the main parties and Amici, other than thus the ones who say were specifically referred to, will give you much shorter time to respond to those issues. And when you get to the podium, please just highlight your submissions. Now, Caroline Chirono, can you take the podium?
Thank you, my lord.
Let me have your submissions, please. Please carry on.
For purposes of record, my name is Caroline Gerono. I appear for the 19th, 20th, and 21st respondents. My Lord, my learned friend, Mr. Mutuma, has taken the court through the process termed popular initiative as it ought to be, and how the appellants, or how the impugned Constitution of Kenya Amendments Bill 2020 was processed. I'll take the court, or my submission rather, is on the part of public participation with respect to the Constitution of Kenya Amendments Bill 2020. My Lord and my ladies, I will begin by drawing the court's attention to our Bundle of Authorities, Volume 2, that is dated 23rd of June 2021, at page 558, that is Raila Odinga, sorry, Your Honor, just a minute. That is paragraph, page 668, Raila Amolo Odinga in another versus IEBC and two others. The learned judges of the Supreme Court, while nullifying the presidential elections of 2017,
yes,
stated that while relying on authorities as stated in that authority, that election is a process. It is not a one-day event. I will not belabor the court because we have filed the authorities and the court can revisit later. And the appellants have indeed confirmed to this honorable court that referendum is an election process, is an equally a process as opposed to an event. And because it is a process, then there are parameters that have to be complied with. We submit, my lords and my ladies, that even if the promoters of the 2020 Amendments Bill had rightfully started the process, I'm avoiding the term initiated, in consideration of Article 257(1) of the Constitution, then there was complete violation of Article 10 and Article 33 of the Constitution. My lords and my ladies, I draw the attention of the court to our authority found in our Bundle of Authorities, Volume 2, at page 558, that is Republic versus IEBC, Expansion National Super Alliance, NASA, and 6 others. The court, as paragraph 160 in that judgment, held that the people of Kenya did not intend that these provisions be merely suggestions, superfluous or ornamental. They did not intend to include these provisions as lofty aspirations. Kenyans intended that the said provisions should have substantive bite and that they will be enforced and implemented. My lords and my ladies, we demonstrated in the High Court chronologically how the promoters of the 2020 Amendment Bill abrogated the provisions of Article 10. And we submit here today that they have not even attempted to tell the court if at all they did comply. My lords and my ladies, learned senior Lucy Kambuni told the court that a promoter would appeal to people whom they deem that they would be moved or convinced by the proposal. in the process of collecting signatures. That means there is a possibility that a promoter of an amendment would go to a particular place, call upon his or her friends, or even pay them, whichever manner, collect the signatures, it doesn't matter, leaving out all the other counties, leaving out the common Mwananchi, who is in Kakuma, who is in Homa Bay, who is in Tana River. The promoters have told this court, or the appellants rather, have told this court that a popular initiative only becomes so at the point of signature collection. My learned friend, Mr. Mutuma, has demonstrated to this court that changes to a constitution by amendment does not begin at the collection of signatures. It begins from the enactment stage. We demonstrate to this court that the bill, the Constitution of Kenya Amendment Bill 2020, I would call the impugned bill, was not prepared in such a manner. It does not comply with Article 10 of the Constitution. There was no public participation. And I demonstrate this way, my lords and my ladies, that the motive of the promoters, as it has been submitted, that it is the executive, the motive, the intention was not presented to the people of Kenya. The first Gazette notice was all about policy issues. The second Gazette notice number 264, which is dated 10th January 2020, includes statutory changes. The recommendation, the terms of reference include statutory changes and constitutional changes. The appellants have not belabored themselves to demonstrate to this court that indeed, when the steering committee went round as they purport to have done, did they present to the people of Kenya that we want to change the constitution? What do you say about this article? What do you say about this clause? Were the people of Kenya informed? To the Constitution and Article 257, did they make it known to the people of Kenya that there is an intention the forward by the BBI steering committee to the president? They told the court that the steering committee held 93 stakeholder meetings. Where were they held? KICC, Laiko Regency, and the offices in Nairobi. My lords and my ladies, this country comprises of people living in 47 counties. The stakeholder meetings were carried out purely in Nairobi. At the point of effecting service upon then the first and second respondents, that is BBI Steering Committee and the BBI National Secretariat, we had a challenge. We had to serve their advocate. That means the offices were not even known to us. What about a common Mwananchi? On that account alone, my lord, I pray that, or I submit that, the High Court was right in holding that there was no proper public participation. I refer the court to the authorities that we have cited, and more specifically, the county government of Kiambu versus Robert Gakuru. It is found in volume 1, Volume 1 of our bundle of authorities at page 125. And your ladyship, Honorable Lady Justice Nambuye, together with the team, upheld the judgment of Honorable Justice Odunga in that there was no public participation in the process of enacting Kiambu Finance Act, and the entire process was nullified on account of lack of public participation. And the courts, both in the Superior Court and in the Appellate Court in this case, made reference to the famous Doctors for Life case, which we have relied on in our written submissions, both at the High Court and before this Honorable Court, and it is in our bundle of authorities, volume 1, as well as in the judgment of the Superior Court, on the emphasis on public participation. That when there is no public participation, any legislation that suffices is invalid by virtue of lack of public participation. My lords and my ladies, I draw your attention to paragraph 22 of that authority, where the court, relying on Doctors for Life case, stated that the bottom line is that public participation must include and be seen to include the dissemination of information, invitation to participation in the process, and consultation on legislation. We submit that this was not adhered to. My lords and my ladies,
yes.
Sorry, my lord. My lords and my ladies, if we get now to the collection of 1 million signatures, as per Article 157(4) of the Constitution, we have laid our basis that at the point of enactment, at the point of formulation of the amendment, the questions to be posed at the referendum, in the event that it would end in a referendum, Wanziko was not involved. Wanziko was never invited. It was an executive affair. At the point of signature collection, were the people of Kenya involved? We submit that they were not. And the appellants have told this court, in their own admission, that the role of Wanziko is preserved for a referendum. That public participation, it was premature to carry out public participation before the referendum is rolled out. We submit that in a situation, in a scenario, my lords and my ladies, where when the bill lands at the president, and the president deems fit that none of the suggested amendments fall under Article 255(1), and so it does not need to go to a referendum. At what point will the views of the Kenyans be absorbed or be incorporated if at the initial stages they were not incorporated? Because prior to the bill getting to the county assemblies, prior to the bill getting to parliament, there is still a window for the Kenyans to make their suggestions as to whether they agree or not on certain elements, on certain suggestions. But once IEBC presents that bill, or those referendum questions, suggestions to the county assemblies. As it is, any public participation undertaken thereafter is inconsequential. So we submit that by closing that chapter and telling the people of Kenya that you wait, referendum is on the way, that is when you will express your views. That is an absolute violation of Article 1 on the sovereignty of the people of Kenya. My lords and my ladies, see my time is up. But I would want to peg the question to the IEBC. IEBC have submitted to this court that their hands are tied. Their duty, their obligation was to only verify, just confirm if the initiative is supported by 1 million registered voters. Article 1888, sub-article 4G of the Constitution gives IEBC the mandate to carry out voter education. What does voter education mean? In election, in a general election, for example, IEBC would conduct civic education that they are going to use, a kind of demo on how the actual election would be. In this context, why would IEBC give a template to the promoters on how to collect signatures and fail to dispense its constitutional duty to tell the registered voters of this country that, look here, something is coming, and this thing is going to affect your day-to-day lives, because if it is approved, it becomes part and parcel of the Constitution, and it will affect every other Kenyan. IEBC would have carried out voter education, tell the people of Kenya how to append their signatures and what they are appending their signatures to. That way, there would have been public participation. In this context, it did not happen. We are told that IEBC, having received so many million signatures, verified it as they call it, and cast it on their website. My lords and my ladies, it baffles me that the Attorney General says that in the event, sorry to digress, but I'll come back to it. In the event that this bill goes for a referendum and that the judges having held that there should be multiple questions as opposed to binary questions, then at paragraph 150 of their submissions, the Attorney General's submissions, that it would disenfranchise Kenyans. That this country consists of 7.8 million adult illiterate adults. Why would it be that it would disenfranchise Kenyans at referendum and not now when they are endorsing a document that they have not read? We submit that there was no public participation from the initial stage to the collection of signatures, and even to the county assembly level, where we gave an example of Siaya County, we gave an example of, there is a case which we have cited, that is Tana River case. I will not refer to it because my time is up, where the court nullified the process, and I pray that this court will have a look at that case and how maybe going forward on the jurisprudence of that case.
What did you call it? Siaya case?
Sorry?
You say it's Tana River County.
Yes, it's a Tana River County case. You will forgive me because my time is up.
No, if it's in your bundle, we'll look at it.
Yes, it's in our bundle of authorities. I submit, therefore, my lords and my ladies, that on the account of violation of Article 10 and Article 33 of the Constitution, that the court rightfully made its findings, and that